I would like to, move on to our next panel, second panel, important fireside chat on the Manifesto on enforcing the law in the age of AI that the Transatlantic Reflection Group developed earlier this year, building upon the first manifesto that we had developed last year on defending democracy and the rule of law in the age of AI. And so I would like to invite on stage Mr. Francesco Lapenta, our moderator, the founding director of the Center for the Future and Innovation Studies at John Cabot University in Rome. Let me also invite Paul Nemitz on stage, the European Commission Digi Justice Principal Advisor, and let me tell you, the leading force behind the manifesto, as well as Commissioner Rebecca K from the Federal Trade Commission. And let me tell you, Commissioner Slaughter, we are thrilled to have you with us today. Thanks for making the trip from DC. It's great, and I look forward to the transatlantic conversation. Francesco, the floor is yours.
So first of all, thank you very much to the Athens Roundtable for hosting this so far amazing conversation. The previous panel provided an incredible map of the territory. Now we have 20 minutes to unpack a rather complex document. So the Manifesto on Enforcing Law in the Age of AI, it's both an ambitious and important document. We'll see later why it's important. The reason why it's ambitious is because it's the product of 2 years investment of over 24 experts from both sides of the Atlantic to reach an agreement on a common regulation for artificial intelligence. So it was 2 years ago that Paul Nemitz with Konstantinos Karakalios and later joined by Nicholas Economou, they formed the Transatlantic Reflection Group on Democracy and the Rule of Law in the Age of Artificial Intelligence. So 2 years is a long time in modern history. The world was different 2 years ago. Relations between the United States and Europe were in a very specific moment historically. And so was the really the optimism or the ambition to find a common ground when it came to regulation of artificial intelligence and data. There was quite a substantial distance. But in that moment, there was the intuition that there needed to be an attempt to bridge the gap and to have a conversation. So the real origin of the group, the Transatlantic Reflection Group, was first and foremost that of proving that experts from the two sides of the Atlantic could reach a consensus. They could reach an agreement on a common ground. It was in that context that the first manifesto was produced, the Manifesto in Defense of Democracy and the Rule of Law. And I quote, that manifesto was a shared vision to safeguard democratic values worldwide, and a call for US, EU leaders to remain committed to coherent laws, the primacy of public interest, and the shaping of the digital economy through democracy on both sides of the Atlantic. It was a very ambitious document that basically acknowledged that we share as much as we don't agree upon. The second manifesto was built on the impetus of the first one, and it's rather ambitious. The second manifesto on enforcing the law in the age of AI focused on the need to adopt and strengthen the enforcement of the law. And the manifesto issued the following recommendations. So the first recommendation is implement international agreements on AI and translate them into national laws and standards. 2, establish new laws and governance mechanism for AI. 3, establish and enforce clear prohibitions for deployment of AI systems that violate fundamental human rights. 4, support coordinated efforts for technological standards, benchmarking, and certifications of compliance. 5, build capacities across institutions to effectively enforce laws. 6, ensure that public interest supersedes countervailing assertions of intellectual property rights. 7, launch a transatlantic observatory for reporting AI incidents to help all developers and deployers of AI systems accountable. 8, empower academia, civil society, and the public to participate meaningfully in oversight and enforcement. 9, invest in the development of trustworthy AI tools to assist in the enforcement of regulatory law. 10, and this is an important one, sanction corporations and executives that violate laws or use AI to undermine the rule of law. So, I mean, as you read these 10 recommendations, you're probably aware of the complexity of actually implementing them. You're probably aware of the saga that there is currently in the United States between California and the American Data Privacy and Protection Act, the complexity of trying to reach an agreement within one system becomes ever more complex when you're trying to talk about the European and American relations. So, given those 10, I'd like to use the 20 minutes to focus on some of the key themes that the manifesto has tried to propose. So the question for our two respondents is, so do we witness, compared to the first manifesto, transatlantic renaissance of the law and the will to see soon more concrete expressions of the community of values between the two great democracies and form law and enforcement cooperation? Is something changed between the first manifesto and the second one in the global conditions? And do you think that now there is actually a will for the United States and the EU to come together to agree on laws that should be enforced on both sides of the Atlantic? Paul?
Well, I would say that certainly since the time of Obama, when the government of the United States was singing from the hymn sheet of Silicon Valley, and then Trump, I don't have to comment on, things have become much more constructive. And I would say in the end, the question, I think, is, are we able to come up with coherent laws? And I think that will remain difficult for reasons of its own in the US. But I think the more important question is the final outcome. And that's why I'm so happy to sit here next to a commissioner from the FTC, because even without a change of laws in Congress, I think the FTC can do a lot. And so in the end, I think the question is, will the regulatory pressure go in the same direction on both sides of the Atlantic? And I think that's where we probably, with the present FTC, may be able to find maybe more convergence than with Congress. But let's hear from Rebecca.
Yeah, well, thank you. And it really is an honor to be here and to get to participate in this incredibly distinguished and important event. And I think Paul echoed very much what I was thinking. I didn't have the privilege of participating in the manifesto, the first or the second one's development. But when I read the manifesto on enforcement, it very much reflects many of the principles that we have adopted at the FTC, including making sure, while we cannot write new laws ourselves, we cannot change the law that we have, we can effectively enforce the law that exists, including with relation to AI. And we have seen that in some of the cases that we have brought, where we have held companies accountable for misrepresenting what data they were collecting and how they were using it to inform their algorithms. We have seen that in the remedies that we pursue, making sure that where we have that kind of misrepresentation, we require companies not only to delete the data that they illegally collected, but also to delete the algorithms that they developed from that data, understanding that the data itself is not what has the value, but the tools that they develop the machine learning with. So I think we've seen it in that. And we have a very big project ongoing at the FTC right now, which is a rulemaking effort on commercial surveillance and data security, which implicates many of these fundamental questions. Now, to be clear, we cannot, by rule, make illegal conduct that is otherwise legal. We cannot change the standards that are in the FTC Act, which prohibit unfair and deceptive acts and practices or unfair methods of competition, but we can articulate with more clarity what types of market practices, including in the space of AI, would constitute unfairness or would constitute deception with respect to consumers. So we opened our initial record with the ANPR, which asked 97 different questions on these topics in August. That record closed a couple of weeks ago. And even in that effort, I think we see something that is reflected in the manifesto, which is it's a public record. All of the submissions are public, and we hope that they will be useful not only to us in our enforcement and rulemaking efforts, but also to legislators as they work through different efforts at new statutes, and to academics and civil society to better understand the way the markets are operating. And one thing we did during the comment period was actively solicit participation from our international partners in the EU and elsewhere to understand their experience with some of these issues and help it inform ours. So I think that also reflects an effort at transatlantic cooperation and coordination that will be very important for us going forward.
So following up on the same theme, Vice President Kaili before just mentioned that whenever you talk about legislation for artificial intelligence specifically, in a way it doesn't make sense to talk only of the agreement between two countries. It doesn't matter how big the two countries or the two geopolitical powers. In the context of the risks that are posed by artificial intelligence, what can be the strategy to expand this form of cooperation, for example, like the one that is fostered by the Manifesto, to include other partners and not necessarily the ones that we agree with? I can see a path to share this understanding with the like-minded countries, but the risks of artificial intelligence cannot be limited to one geopolitical area. Is there a strategy to expand?
I think, of course, the European Union always seeks international dialogue, but I think it would be wrong to say that we seek the Brussels effect. I think that's not a fair description. Our job is to deliver the rights and the promises of constitutional nature to our citizens. So we make laws to ensure, as Vice President Kaili also rightly said, the good life of our citizens. And that's what the legislator's duty in a democracy is about. But of course, the fact is we are a big market, and people look to Brussels for innovation, but not necessarily only technological innovation, but also political and regulatory innovation. That's what we're good in. And that's also something which I think legitimately must shape the world in the future. We must here establish again and again the primacy of democracy over technology and business models. And I think, there are many who are interested in what we're doing. And I would say very clearly, those who want to sell into Europe, whether it's hardware or software, they will have to comply with our rules. And we see also the US being very robust in their own way. And so I am quite confident that there will be business again, like after GDPR, when many American businesses were smart enough to say, from now on, we promise our customers globally, wherever they are in the world, GDPR standards. And, I congratulate the American companies who are just smarter in marketing and doing this than the European companies. Some of them kept on nagging about the costs to business of GDPR and so on, while the Americans already were paying the data protection officer from the marketing budget very smartly. And I think probably the same will happen on the AI Act. And that's not a bad thing. But of course, also politically, the world would be much better if the traditionally leading democracy in the world, namely America, would take things in their own hands and get its act together to make its democracy deliver again in Washington. That would, let's say, reduce the costs of discourses across the Atlantic, which are great and which we do in the Transatlantic Reflection Group and in the TTC and so on, and where we always emphasize our common values. But when it comes to the concreteness of then delivering, it's, let's say, a little bit uneven. So that's why I'm so hopeful that even below the level of new legislation, we see, let's say, an adequate modernity and innovation in interpreting the law and, reframing existing texts, which are sometimes very open. Let's remember the best texts of law are constitutions which are formulated in a very broad manner, and they can stand in the books for hundreds of years. And I think there America is great. And that's why, the FTC is such an important place. But it is also an important place because it combines and thus overcomes the fragmentation which we have here in Europe between competition law, data protection, privacy, and consumer protection in one authority. So, I love to listen to the FTC experience also because that is something which we have to strive to. We have to start working on the big book of coherence, not only between all the different legal acts on digital which we are passing in Europe, but also on the big book of platformization of enforcement and the big book of coherence of the activities of all these different regulators fragmented across member states' borders, and then again also fragmented by sector of activity. My prediction for the future is that we will need to platformize public economic law in such a way that enforcement becomes as seamless as the operation of platforms and multi-purpose technologies. And there, I think, we probably can learn from America.
There's a lot to respond to there. Let me say a couple of things. I think Paul's points about democratic legitimacy resonate a lot with me. It's language you'll hear frequently from our chair. I think that those are really important issues for us that we take very seriously, as is using all of the tools that Congress has given us and fulfilling our statutory mandate. One of the things that Paul mentioned, the structure of the FTC to consider both competition and consumer protection, is something that I think was really underutilized in the past. We really treated these issues as very siloed, and we are working very hard to make sure that we're not looking at things myopically, but instead taking a broader lens to see, because it is not unusual that some of the biggest consumer protection or data privacy problems also arise with companies that have extremely large market power. And that's not a coincidence. And it is not using our structural advantage if we are not looking at that holistically. So I think all of that's true. And then the last point I'll make is convergence of approach is something that is useful for enforcers so that we can be working collaboratively and collectively. I think it is also good for markets. It is not good for market participants to be trying to comply with contradictory laws in different jurisdictions in which they operate or contradictory interpretations of the law. I thought Judge Forrest made a good point earlier about how companies may necessarily come into compliance globally with something that is a more territorial requirement because that is easier and better for them to do. And so I think that is enhanced if we are in communication with our partners, not just in Europe, but internationally and globally, to make sure that we're clear about what we're doing, we're transparent with them, and we are finding synergy and convergence where it exists, both in our statute and in our execution of them.
Thank you. One of the reasons why I was asking that question, to which you really unpacked, is because of the method and nature of the manifesto itself. The manifesto is not an institutional document. Was created independently by experts on the two sides of the Atlantic. And to me, it's important to reflect on the function that such exercises and documents might have in leading different forms of interaction and conversation and to reach different forms of agreement and consensus that perhaps are more complicated by formal interactions. For example, of course, now we have the TTC negotiations underway, but this manifesto seems to be complementary, but also in juxtaposition in terms of method to the way in which those negotiations are conducted. So can you reflect on the function of documents that are created by independent actors in different contexts and how they can contribute to more formal negotiations? Do you see an interaction between the two, and do you see a role for such documents? Should they be formalized, or should they stay as they are now, independent from interaction with these more institutional negotiations?
Well, I think it's a good thing to send signals of ability and willingness to agree. And this can start among academics and civil society and so on. And, you know, thinking people can inspire other thinking people. So I think, you know, this type of work inspires obviously also the more formal discourses. But I think in the transatlantic relationship, generally, we have to get better in concretizing what it actually means when we say we have a community of values. And I think that stays a task before us. And every group which comes together and which is mixed, and it doesn't need to be representative, but, you know, from both sides of the Atlantic and a little bit interdisciplinary, which manages to come up with a consensus document which concretizes this so-called community of value, I think makes an important contribution to this community of value.
I'll just say I agree. I think that they're useful documents and can be very informative. And at least speaking for myself, at my agency, we take very seriously the expressions of goals and principles by NGOs, civil society, international organizations, and cooperation. I think that it can be really useful to inform our work.
All right, so thank you very much. The time is up, but I just want to conclude by saying that the document can be downloaded online. And actually the nature of the document is that it can be signed, so you can participate in this conversation and take the document and lead other conversations in your own groups. So thank you very much to Paul and Rebecca. Thank you.